Hey, good morning, everybody. We're going to get started in a little while. I'm just making sure we're getting the sound check and the PowerPoint and everything's in the right place. All right, I'm going to play around and see how this works. Okay, good. All right, seems to be working good. All right. Well, hello, everyone. My name is Matt Powell, and I'm honored to be here on behalf of Trial Guides. And we're going to talk a little bit about taking small cases to trial. And it's kind of unusual for me to be sitting in my office just talking to, a camera and not having people here to ask questions and stuff. But this is a great way to share information and make sure we all learn a little bit. If there's any technical difficulties, I apologize. This is our first live stream. Let me try a couple things here. The microphone might be a little hot. See if I can tune it down a little bit. Okay, so taking small cases to trial. what's exciting is COVID seems to be winding down and the courts are opening up. And during COVID, there's been just tremendous amounts of educational stuff for us lawyers about how to try cases, but they tend to be about really, really big cases, multi-million-dollar cases. So Aaron Deshaw in Trial Guides asked me to talk about trying smaller cases. And it's kind of interesting. I think the term smaller cases is a little bit of a misnomer. I think it was Russ Herman said to me, there's no such thing as a small case. There's just small lawyers. And I said, well, maybe you're right. And it's not really fair to call them small cases. But every case is a big one, especially to our one client that's there and trying to go through this process. So what I'm going to do is, here's a little disclaimer information. I want to share with you some of the things that we do here at my office to help us try really what I would call a higher volume of cases. And sometimes people go to trial because they're forced to. When the insurance company really makes a really low offer and you don't have a choice, then that makes it easy for us. But sometimes, the way we organize our offices and the way we deal with adjusters, we may take smaller cases to trial and get some really great results. And I'll explain how taking more cases to trial will probably increase your bottom line because the insurance companies will have a greater deal of respect and rate your cases as having a higher value. So let's talk about the point of view of the insurance industry. Theirs is to maintain control of a case and to limit their risk. And when you think about it, how do they do that? The best way they maintain control and limit risk is they have what I would call a parachute. They can pay the money, and as long as the plaintiff will take it, then they're safe, and they've eliminated any risk. And they have also, with statistics and stuff, they kind of use their computers like Colossus to set the values of cases. And really the biggest variable is, when we take that control away from them and we go to trial, then they're really kind of at risk. So, they have the luxury of being able to say, hey, let's just write a check and make this case go away, and then there's no more risk for that one. So let's think about it. They obviously they work their hardest to pay the least possible. That's why we have a lot of work to do. They view cases a certain way and we view them a different way. And sometimes we can write beautiful demand letters and put all kinds of stuff in it, and that may not affect the offer too much. But sometimes we've just got to file the lawsuit and keep going. So what are the factors that they're going to use? Are obviously liability, and you may notice more and more insurance companies talking about comparative fault in demand letters. They're like, well, I know it's a rear-end collision, but we think there's some comparative. They're just doing that to kind of push you off your game, justify the lower offer, and they've been given orders from above, from the mothership, saying, look, this is how we're going to fight that. They also poo-poo the damages, that's fine, but they've got to put these three things all together when they decide to assess the value of a case, and one of them is, what's the risk of actually facing a trial? And if they go to trial, are they going to win? Are they going to lose? Is it going to cost them a lot of money? How about defense costs? How about excess exposure? How about bad faith? They don't like to think about all those things, and they like to save money. And so sometimes, plaintiffs' lawyers are a little complicit because we may accept lower offers and settle the cases. So I think what's the most important point of this presentation is that your reputation is really a very big driver that's going to affect how the insurance company looks at your case. So if you have a good reputation of, wow, this guy files a lot of lawsuits and he goes forward with them, then what's going to happen is your rating is going to be high. And if it's low right now, we're going to talk about making it higher, because the better your rating, the more money you're going to make, the happier clients are going to be. It's going to be easier to resolve the cases. So let's talk a little bit about that. So on a low rating is some law firms or offices or lawyers that never ever file a lawsuit. They have very little risk to the insurance company. They're never going to offer you top dollar. And maybe if the policy limits are really low and the damages are catastrophic, they're not going to take a chance that you may hand off the case to someone else. So what I recommend is, hey, file a lot of lawsuits. If you're the kind of law firm that files lawsuits occasionally, then you'll get a little bit higher settlement. One of the big important things you should consider is, if you file a lawsuit and you pay the filing fee, they probably are going to come running to you and say, hey, all right, you know what, we're going to pay you what you asked for. Take the money now. And you need to ask yourself a question. If you take the money then, you're kind of setting yourself up for them to say, well, if we know they'll take the policy limits or whatever their last demand was after we file a lawsuit, why don't we make them do that? Make them spend the filing fee, the service fee, the time to draft the complaint, to talk to their client. They may force you to file a lot more lawsuits. And unless you make it difficult for them and you say, look, you know what, it's too late. That policy limit offer is gone, or that demand is gone, and now you have to pay more. That is going to be the only way, well, I would say the best way to train the insurance industry or the adjuster that, when you say you're going to file a lawsuit, you mean it, and you're going to take it to trial. The next important thing that the insurance company is looking at is whether you will settle your case at mediation. And this, again, is a very important aspect, where if you go to mediation and you have your client prepared and they don't make a fair offer, or let's say in Florida we have very low policy limits, 10,000. And if you get to mediation and they offer you the policy limits and they say, well, that's all there is, if you take it, then you're kind of hurting yourself and hurting your client, because you've obviously spent a lot of time, money, energy working the case up, going through discovery, and now at mediation, they're like, well, here's the money. So my advice or recommendation would be, at mediation, say, I'm sorry, we are not going to take the policy limits now, or we're not going to take the demand. So we really want to go to trial now because we've spent a lot of time, a lot of money. The client has more treatment. There's more factors going on. So, if you don't pay more than the policy limits, we're not going to be able to settle this case. So, if you get the reputation of, they filed the lawsuit and they tried the cases, then your reputation is going to be very, very high, and they're going to offer you more money. So, how do you change your reputation? You have to take control, and you do that by rejecting their offers, right after you file a lawsuit, reject after the mediation, and then force them to defend the case in front of a jury. And when you start winning these cases, they are going to take you extremely seriously every time you send a letter to them saying, hey, would you like to settle this case short of a lawsuit? So where is our power? Obviously, it's the jury trial. And that's the only place that we really have control and put the insurance company at risk. And they don't like it because they're actuarials, they're bean counters, they like certainty. And when they're in a courtroom, their lawyers saying to them, hey, these lawyers are pretty good, or this case is all right, they may win, or Who knows what a jury's going to do? And so what you're doing is you're taking the pressure and stress that's normally on us and putting it on them. So here are a couple important things to think about. And that is, what is the hard part of going to trial? What can we do to make going to trial easier? And what do we need to know? Trial can be a little bit of a scary place, but when you really think about it, there's only some limited information that you really need to worry about. And there's not a whole lot you need to know. I mean, you went to law school, you're a plaintiff's lawyer, and you know what's going on. What's the scary part? Yeah, there's a little scary part involved in going to trial. And is it worth taking small cases to trial? So let's talk about what's the hard part. Well, obviously it is more work. There's a lot that's going to happen with discovery, interrogatories, depositions, requests to produce, motions to compel, motions to dismiss. It does take time. You have to sit down and be geared up and ready to do the work that needs to be done to get your case moving forward. And obviously it does cost money. There's filing fees, service fees, court reporter fees, expert fees. And it is a little bit disruptive. You're sort of at the beck and call of the court, and suddenly you're in trial and your schedule gets messed up, and it's a little bit of a thing that you got to deal with that. Let me suggest to you that when you file a lawsuit, it's more work for you, but it's also more work for the defense. It takes time. Yes, it does. Let's look at it from the defense perspective. They've got an adjuster who's got to fill out all these reports, and he's always talking to their attorney, whether it's in-house or out-house, and it costs money. The insurance company's spending a lot of money and resources defending the lawsuit that they probably could have settled if they'd been fair. So what do we need to know? Obviously, every case has unique facts, but for the large majority of our cases, let's say they're car crash cases, they're pretty similar. In medicine, typically the injuries in these smaller cases are very similar, and we need to learn the basic anatomy, the terms, the doctors. It's not really difficult, complex stuff. And we need to know the law. So, the law will come, it's easy to do. We just got to sit down and crack the books a little bit and collect the cases. So what's the scary part? It is scary. We could lose, walking into a courtroom and saying, hey, I'm a lawyer and I'm going to present this case. I represent my client here, is a little bit of an uncomfortable place for most anyone. It certainly is uncomfortable for the client. And I can tell you that as time goes by, you get more and more comfortable trying cases. And I always tell people, hey, we all want to try really big cases, but let me tell you, you better practice with small cases and get proficient and comfortable and good at trying cases, because when a big one plops in your lap and you haven't tried a case in 3 years and you're all rusty and everything's difficult for you to do, you may not do a really good job. So trying small cases is really important to get comfortable. And you may ask yourself, well, what kind of person is it, that makes a good trial lawyer? I'm just not that kind of person. I suggest to you that, I'll tell you, I'm pretty much of an introverted person. I'm not one of these outgoing, hey, hang out, chatting people up at parties and stuff like that. But when I'm in a courtroom and we have a set pattern, rigid steps we're going to take, and we're going to explain things, I get pretty comfortable there, and I like it. And many of us lawyers are kind of nerdy bookworms, and some of us are outgoing. It doesn't really matter. You're going to find your style and you're going to find your stride. Just get back in the courtroom. So it's no fun having the risk of losing, and it's painful and it's embarrassing when we do. But it's also greatly rewarding when we do win. I mean, there's nothing better than that. So, and the other thing is when you lose, sometimes you're not going to get paid, your client's not going to get paid, they're going to have financial problems that are going to bother them, the medical bills are probably outstanding. So that is the scary part. So is it worth taking small cases to trial? Well, I think so, because it obviously is going to help build your skills. And I'd rather get good on a smaller case where, my client's hopefully not catastrophically injured and have a difficult time if I wasn't able to do a good job and win the case for them. So smaller cases are important. And absolutely, it's going to build your reputation. When you're trying small cases and lots of them, the insurance company keeps track of every move you make, every mediation, every settlement, and so they're going to pay you more money on all of your other cases. Yep. And it will increase those value of those cases. Okay, so how is the client? And are we instilling confidence in them, or are we causing them to be afraid? And I can tell you, after being a lawyer now for 30 years and being active in trying cases, I have a lot of lawyers come up to me and they go, Matt, I just can't seem to get to trial. My clients always want me to settle, And I think, wow, that's interesting, because my clients, maybe they're just being framed differently, or maybe it's the discussions that I'm having with them that are making my clients say, you know what, I want to go to trial. I know what the risks are, but I'm not scared to death of them. I want justice, and if the insurance company is going to not be right with us, then let's go to trial. So think about some of the things that you're communicating to your client, and if you're scared and you're making them scared, then you're obviously not going to get to trial. But you might want to think about that, because don't let that be, the client's driving the case, but we have to give them good advice and help them and support them and encourage them to keep going. So I made this little graph here, and I'm going to share it with you. And this is really talking about if and when you should settle your case. And here we go. So the value of the case is pretty low really early. It's going back and forth. You file a lawsuit, it starts going up a little bit more. The plaintiff does good in their deposition, it increases in value. Then you get to mediation, and after mediation, typically that's when I find that the case increases its value dramatically. And the closer and closer and closer you get to trial, the scarier it is for the insurance company, and the more money that they are going to be willing to pay you. So if obviously you're not going to trial, we're going to play it a second time. If the insurance company knows you're not going to go to trial, they're never going to make a big offer. You're never going to get full value for the case. So, and there's nothing worse than a continuance, because it causes the value of your case to drop, at least for a while. All right. Do you guys have questions? Please type them in there, and we will get to them. So I want you to think about for a moment, imagine if you could do a mock jury trial, and we're going to use 30 mock jurors. We're going to use a skilled defense lawyer. We're going to have a judge, a retired judge, sitting on the bench. We're going to have someone appointed to be a bailiff. Someone will pretend to be a clerk. We're going to bring in witnesses, some lay, some experts, some police. We're going to have exhibits, and we're going to host this all in a very nice courtroom. What would that cost? $30,000, $50,000, $100,000 to have all that talent? Well, you get this stuff for free if you try a case. So, I mean, they present all the jurors and the judge and the defense lawyer shows up, and it's really a pretty awesome experience. All right, so if you've seen me speak before for Trial Guides or actually other places, I'm always talking about how important systems are to help us become more efficient. And I always tell people the story that before law school, when I was in college, I worked at McDonald's. And believe it or not, I thought that working at McDonald's was a great learning experience for me, because I realized and could appreciate how they had systems for every single thing, whether it's to put ice in a cup and fill it with Coke and put a lid on it and deliver it, to make French fries, hamburgers, cheeseburgers. They're just doing the same thing over and over and over, and they have a very organized, detailed system so that it's efficient. And so what I would encourage everyone to do is to start developing systems in your office to help you go to trial. And the more systems you have, the more efficient it is, the more predictability it is, the less stress there is on you and on the staff. So let's talk about systems and efficiency. So, all right, let's talk about getting to trial. Obviously, everyone here can type up and prepare a complaint. I will tell you that I like to keep my complaints rather simple, close to the Supreme Court recommended forms, because it streamlines the motions to dismiss. Getting service on the defendants, I like to hire the most efficient, fastest process servers I can find. Discovery, okay, I highly recommend that if you're going to be filing, let's just use, for example, car crash complaints, figure out what discovery you're going to send and type it up and prepare it with the complaint. I typically send a notice of taking the video deposition of the defendant and a request to produce for documents, photographs, records, that sort of thing. I tend not to send interrogatory questions when I file a lawsuit, because I feel that that gives the defense lawyer and the defendant a reason to have a meeting, to sit down and start communicating together with how are they going to answer this lawsuit. And when they sit there and work on the interrogatories, it's a really good bonding situation for the defense lawyer and their client to talk about the case. So I leave the interrogatories out, and I file a lawsuit with a notice of taking deposition with a little footnote that says, hey, I know that I selected the date because I filed the lawsuit and I don't know who the defense lawyer is, but if you'll call me, we'll obviously, be courteous and reschedule the time that is convenient for the lawyer on the other side. But we won't agree to delay the taking of the defendant's deposition till, anything, discovery's done or whatever the requests are. So I keep that pressure on them. And I can't tell you how many times I've showed up for a deposition when they were live and the defense lawyer says, hey, can I have a moment? I've got to talk to my client. And you can tell that obviously they have never met before. They haven't had a chance to coach the witness. And so it gives us really a better shot at finding out what really happened and getting clearer answers and a better result on our depositions. Mediation, I tell my clients, please don't get your hopes up. I mean, I have a whole video on YouTube that says how mediation works. And unfortunately, as many of us have experienced, mediation is oftentimes an opportunity for the defense to kind of scare, intimidate, or beat up our clients and, make them feel uncertain about their future. And sometimes the defense will use mediation to help drive a wedge between the plaintiff's lawyer and their client. And they do this because some lawyers tell their clients, hey, mediation is going to be great. We're going to get your case settled and everyone's going to be happy and this is going to be the best day in the whole case's life. And then you get there and suddenly the offer is like, sorry, we're not offering hardly anything. And as a result, people like say to their lawyer, well, how come you said this was going to be such a great day and now we can't settle the case? All right. I got a question here. Let me hop to it. Are you required to take policy limits on a demand letter? That's a great question, and I'm going to give you my perspective as a Florida lawyer. And in Florida, there is bad faith. In some states, I know that it's very difficult. If I have a small policy limit and I have catastrophic damages, I send a letter saying, please make an offer to settle this case. And I don't really make a demand at all. And I say, I'd like you to evaluate this case, give you some medical records, give you an authorization, tell you where to go get records if you want, Mr. Insurance Company, but make me an offer. And then I step back. If the policy limits are adequate for what we anticipate the damages are, then I will send a policy limits demand letter. And if they pay the policy limits, then hopefully me and my client are happy, and that's it. But if they don't, and my client says, look, I want the policy limits, then we're off to the races, and I won't settle the case for less than the policy limits. And then if it's, catastrophic damages, or let's say it's low damages, but really, really high insurance limits, well, sending a demand letter for the policy limits probably isn't really getting you anywhere, but you certainly don't want to go too quick and not have your client's damages fully vetted by the doctors reaching MMI. So I hope that kind of answered your question. And if not, ask me another one. Okay, so I can tell you that I love pretrial conferences because that's really where you can see the fear starting to move from the plaintiff's side to the defense. The defense lawyer's like, oh my gosh, I'm really going to have to try this case. And the judge is like, yeah, we're going to try this case. Get ready. Stop filing bogus motions. You got deadlines you got to meet. So I like pretrial conferences. It's probably the most fun hearing you get. Then there's the trial. And I would suggest that keeping your trial simple and moving along quickly and keeping the jurors engaged is the key to success. And it's hard for us to do because we don't know what to leave out. So let's talk about the phases of a trial. And once you get comfortable with each of these as a phase, then you're good to go. Jury selection or voir dire, opening, your case in chief, then dealing with the defense, and then closing argument. So it's really pretty simple. Let's talk about the law. So you need to know the law for jury selection. And what's great in Florida is that the jury selection laws for civil and criminal cases are the same. And there's just so many cases. When I say so many, there's a finite number of cases. And actually, after you get them all and you read them all, you can set them up into certain categories, and you realize that the Florida case law and jury selection is very clear, and you just need to know the exceptions. And once you build a research library, you're good to go. You need to talk to the judge and find out what their preferences are, how much time they're going to give you. You need to know the law and what you can and cannot ask. You really need to know cause very, very well. You need to know your preemptory challenges, and you need to know the other little kind of nuances, things like asking for additional preemptory challenges. What is a Neal challenge? Or every state has a different, buzzword for, discriminatory preemptory challenges. So once you get that figured out, it's pretty good. All right, so the next phase is knowing the law on opening statement. You need to find out what the judge wants as far as Are they going to let you move around? How long are you going to get to go? You need to know the law on what you can and cannot say. You need to know whether you can use demonstrative aids in your opening, and you need to be prepared to handle objections. And you should have a research binder ready to go on opening statements. So if something comes up, you say, Judge, I've got the law right here. Let me show it to you. The law of evidence. This is another area where you need to have binders ready to go. The main issues are, hearsay, documentary evidence, physical evidence, and you should have your binder set up and ready to go with that as well. All right, so let's talk about templates. I love templates, and I have a lot of templates. And so I have direct examination templates that I've pre-written that are designed for my client, or an eyewitness, or a physician. Each one of these is a template. And when my staff is helping me prepare for a trial, we obviously insert the template, and it's got search and replace, so it's putting the client's name, the date of the accident, the witness's name in the right place, the key facts, maybe the statement of the case. So it's all there in a really organized template. And what I tend to do is I overbuild my template, and I have a lot more in it than I would ever ask. But some cases, maybe a defense innuendo is low property damage, so maybe I need to focus on that a little bit more. Or maybe I don't need to in this case. So what I recommend you do is build your templates so that they're rather robust, and they will help you, handle each witness. All right, so let's see. So I also have templates, and this is really important. The jury instructions, I can't stress how valuable they are to have them in your trial notebook early, and to know exactly what it is that the jury is going to be asked by the court to do. And what I do is I tailor my direct examinations to make sure that it fits with the language and the verbs in either the jury instructions or the verdict form. So that's something that you want to kind of build into this. Like for your physicians, maybe permanency threshold is something you have to deal with. Causation, obviously. You might want to deal with whether the past medical bills were reasonable, what future medical bills there will be, that sort of thing. Let's see. The other thing is, I've got to make sure that I know all of the elements that I have to prove, and I have to kind of have an elements template. And I say, which witnesses am I going to use and what evidence, so that it's organized. And then I actually put that piece of the template into each witness's file. All right, you need to know the law on directed verdicts. You're going to be fighting off directed verdicts, and you need to be able to present some directed verdicts. And you want to have the cases that support granting or denying it. All right. Defense witnesses. Believe it or not, cross-examination is a wonderful skill, and we're not here to talk about how to do it, but there's certain things that you're going to see over and over and over. So have your templates ready. Go watch other people's trials. Ask other lawyers. You're going to come up with some great ideas, some great questions, and I'm always improving my templates, and that's why I call it a template. It's literally in our software, and if I hear something and I like something, Keith Mitnick comes up with stuff all the time. I just go in and I add that to my template, so the next trial, boom, it prints and comes out, and it's right there. Closing arguments. Okay, you need to know the law on that too, but you need to have a template on what you're going to cover, how much time, and kind of the visual aids you're going to use. So, this is something that shouldn't be a surprise to you. You should be organized, and it should be easy to go and easy to do. I can tell you that you need to have a whole section for the defendant's closing, keeping track of their innuendos and knowing when you should make objections and what are the grounds, and having the law on that as well. And a rebuttal template is already in my cases because I know what the defense is going to say, pretty much. And all I need to do is listen carefully to see if what really applies and what maybe they got some ground on that I need to address. All right. So let's talk about technology in trial. I can tell you that the low technology stuff like a flip chart is probably one of the most powerful tools. Make sure you love, embrace, and use your flip charts. Elmos are great. The Keenan case presentation creates timelines for you. TrialPad is another wonderful, powerful tool that allows you to really present a lot of evidence quickly. And I like to use an Apple TV hooked up to the projector, or just a big screen. I use the iPad to present TrialPad and Keenan case presentation system, and PowerPoints are good. And whatever, use technology to help make your trial go faster. All right, so calling witnesses at trial. If COVID has done anything, it has probably taught us how we can use technology to call witnesses remotely. And so I really like to call witnesses via Zoom rather than bring them down to the courthouse. And I'm picky about the ones that I want to come live and the ones that I don't want. So like if I've got a great expert witness and he lives pretty far away, I'm going to have him come in on Zoom. I don't have to pay for him to travel, spend the night, whatever. It's just a lot cheaper if he can sit at his desk and present his testimony. And I think jurors these days and judges like it a lot. So before and after witnesses, you know what? Before they're hard, it's inconvenient, I don't want to come to the courthouse, I'm nervous. So suddenly you got a before and after witness that maybe lives across the country, and it's pretty easy for them to show up via Zoom. Okay, so trial notebooks. And there's so many great books out there that you can get. There's so many great systems for building your trial notebooks. I'm not going to go into that very far, but I am going to share with you, these are the general things that I have in my trial notebook, and this is the way I sort of organize it. And I have witness binders, and I set them up with templates for each type of witness. These are how I'm organized. I've got my client binder templates, and these are the things that I put inside them. Their interrogatories, their depositions, the demonstrative aids I'm going to use, their medical timeline. I prepare a designation that I would use to rehabilitate if the defense starts to read parts of my client's deposition. I want to have another part that I'm ready to play on the way back. Question is, can you get a copy of this PowerPoint? The answer is yes. When this thing is over, this video will be on YouTube forever and ever, I think. So it'll be available there. And we'll probably have a link so you could click on it and download it. Good question. Okay, so this is my binder cart, and I bought a library cart, and I like the binder tech systems because they're easy to open and organize and manage. And so I color code exhibits and whether the witnesses are for the plaintiff or the defense. And I love flip charts, and I find that most of the flip charts that some courts have are too flimsy. So I went out and bought this. It's called a King flip chart. It's called a double truck. So it's double wide, and it's a really nice tool. So let's talk about keeping the costs low. I can tell you that I love to just make a life care plan on the fly. by asking my doctors, what's the treatment, what's the cost, how often, and duration. So that's a really powerful thing. The other thing I wanted to share with you is that you can get software called the Keen and Case Presentation System for the iPad, and it makes timelines really nicely, and they're free. And so I'm going to show you, this is a calendar timeline, and a calendar timeline, in my opinion, is best used when you have someone who has many years of no treatment, and then suddenly they get into a car accident, which is October 14th on this calendar. You can click on it, you can add exhibits or medical records or photographs to each one of these data points, and then it shows how the treatment has increased, and look at all the times they had to go to the doctors after the crash. And I think this is a powerful way to communicate information to a jury or a judge or arbitration panel. And it's easy to set up. You can import the data into the software, and you can attach the documents, and it's really a nice way to show a lot of information quickly. This next thing is a clock timeline, and this one, it looks like a clock, and this works good if you have events that all take place in either 12 hours or 24 hours. You can make a time clock as little as 1 hour too. And again, all these little events, you program them in there, and you can have photographs, you can have clips, you can attach media to each one of these events. And I just wanted to just kind of show you that. All right. Good question. So I'm going to address that question about how to do this inexpensive in a second. Let me get through this last timeline. This is the linear timeline, and I'm going to show you how and where to get this timeline software. So this is a linear timeline, and you just put the events in, and you can move it around. It's very dynamic. So when you're presenting this to a jury, you can move things around, change the color, the fonts, attach pictures, do whatever you need to. So that's the linear timeline. And you can go backwards and forwards, and the linear timeline does a lot of neat stuff. Okay, so let me go to the next page. Okay, so the app, it only works on an iPad, and it's called KCPS. And if you go to KeenanCPS.com, you can download the app. All right, so my point is, your reputation for trying cases is the key to success, in my opinion. The more cases you try, the better you try them. The more often you try them, the better you're going to get. It's like any skill. The more you do it, the better you get at it. And so a really good question is, hey, Matt, what are you going to do when a case's value is really in the $10,000 to $20,000 range? And I would say that the only reason that you have to try a case where you're seeking $10,000 or $15,000 or $20,000 is because they made either a no offer or a really low offer. And what I recommend you do is keep the case costs as low as you can, and plead it, do the motion practice, but treat it as though it is a big case. I know that you were probably going to lose money on it, but what you're doing is you're building your reputation, and they're going to not jerk you around and give you lowball offers when they know that you have the chutzpah to go and try the case. If you've got the gumption and you're like, hey, if you don't make this fair, I'm going to go to trial, and I'm going to make you spend a lot of money. I'm going to get a verdict. I'm going to make your defendant, your client, be very upset, nervous, and scared that they're being sued when you could have easily settled this case. And, we ask for more than the policy limits after, if they don't pay us, then we're actually going to seek as large of a verdict as we can. And we put as much pressure on the defense lawyer and the insurance company and the adjuster. The adjuster is probably going to have a difficult time explaining to their higher-ups why they didn't offer you the $10,000 or $25,000 policy limits, and now they're embroiled in a very expensive lawsuit. And since the plaintiff has sought more than the policy limits, they can't use their in-house counsel lawyers. Now they got to pay an outside counsel lawyer a lot of money, and he's running up the bills, and it's getting very expensive and painful for that adjuster and the insurance company. And so when you say no to the policy limits at mediation, they're like, whoa, this is a fire. We got a problem. So how do I keep costs down? If the defense is going to depose my treating doctors, I'll cross-notice it in video, and I'll probably play the video at trial rather than bring the doctor live. I'm not going to go real heavy on court reporters and experts if I can. I want to keep it simple. So those are my tips on that. So I hope you've enjoyed this presentation. I think I went a little over time. If you have questions, my email is right there, matt@mattlaw.com. I encourage everyone to try as many cases as you can. The more we get into the courtroom and the more we put the defense at risk, the more we expose their kind of tricks and stuff, I think the better it will be for all of us. Okay. So my recommendation, it's funny, my life as a trial lawyer is that I did insurance defense work for 6 months, and I really did not like it, and I quit, and I went out on my own and hung my own shingle. And I can tell you it was really, really hard to try a case when you're a small office, one lawyer, one secretary. Cash flow's always a challenge. But slowly, little cases after little cases, I was able to build and build and build and grow and work into systems. So my advice for you is, if you're a small shop or you're just getting started, focus on the templates and make them really nice and make them yours. And then when you start getting some success, you're going to find that you can have your staff help build and organize your cases for trial. The 1 year that I tried so many jury trials, I was able to do so because, we've got 3 lawyers here, we've got a lot of staff, and every case was worked up in a very similar manner, sort of like McDonald's, following systems. And so that when I picked up a binder, I knew what's going to be in there, what I need, all the tools are there. And so I was able to really get to the heart of the coconut quickly. So those are my advice, and I cheer you on. Please go out there and try cases, have fun, make it like a passion of yours, and more of a pleasurable experience rather than the headaches and the fear that most of us start off with. So thank you very much. And there is the information. And if I can help anyone, please reach out to me, phone, email, and share your experiences with me. And I want to thank Trial Guides and Aaron for allowing me to make this presentation. Thank you.